So IP consists of mainly three things. One is trademark, copyright, and patents. They are called IP because IP stands for intellectual property. These are legally protected properties. So you can use it for your own. You can basically let other people use it in forms of licensing. And you can also sell it if you wanted to. IP is the only tangible asset that they can show to the other people, such as outside investors. You can come up with the business plans, visions, and big dreams, but sometimes that have to be backed up by something concrete. And having IP in tangible form helps the business a lot, especially when you're talking to the outside investors. So trademark, copyright, and patents are all important assets. However, as you said, there's cost, business, and time issues. So they have to be carefully balanced. However, the patent, as I said, probably is the easiest tangible asset to appeal the company's value to the outside investors and clients as well. So if you have to balance the three, my personal recommendation is to put the patents first, so that if you could identify tangible asset that can be that can achieve the patent, maybe that could be a bit more higher priority compared to other assets. So trademark could be your company name, your company slogan that's unique enough to the point where consumers in general can identify the service or product to you. So when you see yellow M and say McDonald's, general public will associate that with McDonald's. If you change that to red and put Z at the end and say we are different from McDonald's, we are McDonald's, that doesn't fly. So it's very important that if you have enough consumer basis which identifies and associates your brand to the logo or trade dress, it's very important for you to protect it. And you also have to, in addition to registration, you also have to actively protect it, which means that if you see other people stepping onto your IP, you have to send cease and desist letter asking them to stop it. And you have to enforce your right. Otherwise, you could be seen as abandoning your own right. It's very important to find a lawyer who really understands your product or service. If you're a tech company, go find a lawyer with tech background. If you're a medical engineering company, go find some lawyer with medical engineering background, because it is critical for the lawyers to understand your product and services so that they can correctly understand your issues. Just don't jump onto the big names, because it's very important to have a lawyer who know and who's interested in your product and services so that they can give appropriate advice. If you are a software company, look for some work experience in the software industry. That's a very good indicator. Or look at the degrees they have. If they have degree in law, don't expect them to understand your DNA testing kit, because they most likely do not understand your service or product.